Hi everyone, my name is Garrett Lyle, and I'm a lead investigator with the Division of Real Estate, here to discuss some of the questions and concerns from the real estate brokerage community regarding the practice of providing referral fees. There appears to be a common belief within the industry that any referral fee paid from a broker to an unlicensed individual is always a violation of Colorado license law. While this may not necessarily be so, there are many legal factors and multiple layers of state and federal regulations that should be considered before implementing any type of referral fee program within your practice. Let's take a minute to review some relevant information. Commission Position 2, found in Chapter 3 of the Colorado Real Estate Manual, specifically addresses this issue, stating in part, payment for providing a name to a licensed broker is not specifically addressed in Colorado statute. However, it would be illegal to pay such a fee to anyone performing acts that require a license, such as negotiating, listing, and contracting. Care should be taken. At best, the unlicensed referrer can have no active involvement in the transaction beyond merely giving to a licensee the name of a prospective buyer, seller, or tenant. Commission Position 2 specifically states that if the payment is simply for the referral of a name to a licensee, with no further activity on the part of the referrer, and the referrer is not a provider of a settlement service, the Commission will not consider it to be a violation of the license law. This direction of the Commission would appear to allow the payment of a referral fee to unlicensed individuals, provided they are not settlement service providers and not performing acts that require a license. Consequently, it is important that you make sure to take time and review the partial list of roles identified as settlement service providers found in Colorado Revised Statutes 1210-218. Those activities requiring a real estate license, plus those exempt, are identified in 1210-201, 6A and B of the Colorado Revised Statutes. However, Commission Position 2 also notes that Colorado license law permits a real estate broker to pay a referral fee if it is not prohibited by the federal Real Estate Settlement Procedures Act of 1974, or RESPA, and a reasonable cause for payment exists. This may be the most important direction that a licensee should consider. Regardless of what practices were previously or are currently allowable under Colorado law, 1210-304 of the Colorado Revised Statutes makes state compliance dependent upon federal RESPA regulation. Remember, the Consumer Financial Protection Bureau, or CFPB, is the primary federal agency tasked with enforcing RESPA. Consequently, if a licensee has questions about the legality of a proposed referral fee program, the division is probably not the most appropriate agency to contact. If you are providing a referral fee to a settlement service provider or to an unlicensed individual for performing acts that require a real estate license, 1210-304 of the Colorado Revised Statutes and Commission Rule E22, soon to be Rule 6.21, make it pretty clear that conduct is a violation of state law. However, if a licensee wants to ensure that their proposed activity is actually compliant with all state and federal regulations, the CFPB and legal counsel should be contacted. Thank you for listening. This has been a licensee advisory from the Division of Real Estate.